Welcome to another episode on the Law Report. This is episode number 6. Today, I would like to speak to you about the defense of necessity in criminal cases. And I pose the question, does the defense really exist in criminal law? Before I go any further, disclaimer. This is not legal advice, should not be construed as such. For legal advice, please contact a competent attorney. So, what is the defense of necessity? The defense of necessity in criminal law is where a defendant argues that it was necessary for him or her to commit a crime. The defense of necessity often operates where the defendant is faced with two stark choices. One, to commit the crime, or two, to suffer or cause another extreme hardship. There are 3 requirements for the application of the defense. 1, the act is needed to avoid inevitable and irreparable evil. No more should be done than is reasonably necessary for the purpose to be achieved. And 3, the evil inflicted must not be disproportionate to the evil avoided. Does the doctrine of necessity exist in English law? For eons, questions have been raised as to whether the defense of necessity existed in English law. It was raised in the infamous case of Dudley and Stevens, 1884, where it was unsuccessful, as it was held that the defense of necessity could not be raised for murder offenses. And this case is very interesting, and I think, or I believe, that I should just go into some of the brief facts of this case. The 2 defendants, Dudley and Stevens, became shipwrecked by a storm. They were forced to abandon their ship and were stranded in a small emergency boat with 2 others, including a young cabin boy. They had been stranded for 18 days. The food ran out after 7 days, and they had no water for 5 days. Dudley and Stevens decided to draw straws to decide who was the weakest among them that they could eat to survive. Dudley and Stevens, having drawn straws, cut the cabin boy's throat. He was too ill to put up any resistance. The men fed on the boy and were rescued 4 days later. And their return to England, Dudley and Stevens were charged with the boy's murder. They argued the defense of necessity. The defendants were convicted of murder. The defense of necessity was rejected. They were sentenced to death, but then granted a pardon by the Crown and served only 6 months imprisonment. Lord Cordray CJ, or the Chief Justice at the time, had the following to say in delivering his judgment, and I quote, "Now it is admitted that the deliberate killing of an unoffending and unresisting boy was clearly murder, unless the killing can be justified by some well-recognized, admitted excuse in law. It is further admitted that there was in this case no such excuse, unless the killing was justified by what has been called necessity. But the temptation to act which existed here was not what the law has ever called necessity, nor is this to be regretted. Though law and morality are not the same, and many things may be immoral which are not necessarily illegal, yet the absolute divorce of law from morality would be a fatal consequence, and such divorce would follow if the temptation to murder in this case were to be held by law an absolute defense of it. It is not needful to point out the awful danger of admitting the principle which has been contended for. Who is to be the judge of this sort of necessity? By what measure is the comparative value of lives to be measured? Is it to be strength or intellect or what? It is plain that the principle leaves to him who is to profit by it to determine the necessity which will justify him in deliberately taking another's life to save his own. In this case, the weakest, the youngest, the most unresisting was chosen. Was it more necessary to kill him than one of the grown men? The answer must be no. So clearly, Lord Coleridge was having none of it, and the defense of necessity in this case was squarely rejected. In the case of Kitson, 1955 Court of Appeal case, the defense of necessity was again raised and again squarely rejected by the court. In this case, Kitson was a passenger in his brother-in-law's car. He was intoxicated and had fallen asleep. He woke up to find that the driver had disappeared and the car was coasting down a hill. He grabbed the steering wheel and managed to safely steer the car and stop. His conviction for driving under the influence of alcohol was upheld. Lord Denning, in two cases in 1971, was very critical of the defense of necessity. In the case of Southwark and Williams, 1971, a Court of Appeal case, Lord Denning had the following to say, and I quote, "Necessity would open a door which no man could shut. If hunger were once allowed to be an excuse for stealing, the plea would be an excuse for all sorts of wrongdoing. The courts must take a firm stand." And then in the case of Bokcho and GLC of 1971, Lord Denning had the following to say, "A driver of a fire engine with ladders approaches the traffic lights. He sees 20 yards down the road a blazing house with a man at an upstairs window in extreme peril. The road is clear in all directions. At that moment, the light turned red. Is the driver to wait for 60 seconds or more for the light to turn green? If the driver waits for that time, the man's life will be lost. The circumstances go to mitigation and do not take away his guilt." So Lord Denning was clear that even in such an extreme case, the defense of necessity will not hold. In the case of Trehan and DPP 1994, a case heard in the Divisional Court, and the case heard in 1994 is a fairly recent case in terms of case laws. In this case, a dog owner removed the muzzle from his pit bull terrier whilst in public as the dog was suffering from kennel cough. His conviction for allowing a pit bull terrier to be in a public place without being muzzled under section 1(2) subsection D of the Dangerous Dogs Act 1991 was upheld. The court had the following to say, and I quote, "The Act does not in terms allow the person in control of the dog to make a valued judgment as between what is good for the dog and what is good for the rest of mankind. We have here an absolute prohibition, and a breach of that prohibition is to be followed by an order for the dog's destruction, however blameless the dog and its owner." So even in such an extreme case, again, the defense of necessity fell flat on its face. In the case of Aaron Quayle and others, 2005 Court of Appeal case, 5 appeals were jointly heard with one Attorney General reference. Each was concerned with the applicability of the defense of necessity in relation to offenses involving possession, cultivation, production, and importation of cannabis. In all the appeals, the appellants argued that the cannabis was for medical purposes, for relief of pain for various medical ailments, including HIV, severe back pain, etc. It was held that neither the defense of necessity nor duress of circumstances was applicable in such circumstances. This again is another occasion where the defense of necessity fell flat on its face. While it appears that the defense of necessity is often used successfully to protect medical professionals perceived to be acting in the best interest of their patients, the defense of necessity has been denied in self-medication cases involving cannabis. In the case of Altam 2006, another Court of Appeal case, the appellant had been in a serious car accident some 14 years before he was charged with the offense of possession of 5 grams of cannabis resin. He pleaded guilty as the judge had ruled that the defense of necessity could not be raised following the decision in R and Quayle and others. The defendant in this case appealed against the judge's ruling, arguing that the denial of the defense amounted to a breach of Article 3 of the European Convention on Human Rights. It was held that the judge was correct in denying the defendant the defense of necessity. The appeal was dismissed and his conviction was upheld. In conclusion, it appears that although in principle the defense of necessity exists, it is only in the rarest of circumstances that the defense will succeed. On the other hand, in medical cases, the defense was upheld in several cases. Thank you.